Thanksgiving week of expert testimonies and legal maneuvers. As the Trump civil fraud trial enters its 32nd day on November 20, 2023, the legal battle spearheaded by New York Attorney General Letitia James against the former president continues to captivate the nation. The courtroom drama has been marked by a parade of expert witnesses and strategic legal maneuvers that underscore the high-stakes nature of the proceedings. The defense's strategy. Throughout the trial, Donald J. Trump's defense team has worked tirelessly to present a comprehensive view of his business operations. This week promises a deeper dive into the intricacies of Trump's financial dealings, with the defense arguing that the valuations of assets were well within normal boundaries. The defense contends that the differing valuations, a central point of contention, are common in the complex world of real estate. Motion for mistrial denied. Last week, Mr. Trump's lawyers called for a mistrial, stating the tangible and overwhelming evidence of bias by Justice Engoron and Ms. Greenfield, both Democrats. They argued that Ms. Greenfield's frequent discussions with the judge and her prominence suggest that she is co-judging. They also cited Justice Engoron sharing articles about the case with his high school alumni newsletter, and political donations made by Ms. Greenfield. Mr. Keiss, representing Mr. Trump, expressed his concern that an openly and overtly partisan individual would play a role in the decision-making process of such an unprecedented case, which goes against the foundational principles of American judicial independence. However, Justice Engoron denied the request for a mistrial on Friday, stating that he would consult on the trial record, the law, and the facts before issuing any ruling, and that it was within his absolute discretion to do so. This decision is likely to be appealed. Justice Engoron made it clear that his rulings were his alone. Expert witnesses. The defense's strategy heavily relies on expert witnesses, with insurance expert David Miller and former Trump Organization controller Jeffrey McConney taking the stand. Miller's testimony seeks to demonstrate that the Trump Organization's interactions with insurers were legitimate and driven by standard business considerations, rather than fraudulent intent. McConney, a key figure in the Trump Organization, testified about correcting an inflated valuation related to Ivanka Trump's apartment, shedding light on the complex nature of asset valuation within the organization. Challenges to the defense. Despite the defense's efforts, the trial has not been without challenges. The presiding judge, Arthur F. Engoron, had already ruled before the trial that Trump and the other defendants were liable for fraud. The judge, who will determine the punishment, has faced accusations of bias, prompting Trump's legal team to call for a mistrial. The motion was denied, but the issue remains a focal point of the trial. Gag order controversy. A notable subplot in this legal saga involves a temporary lifting of the gag order imposed on Trump. His social media posts, particularly those targeting the judge and his law clerk, have stirred controversy and led to fines totaling $15,000. Trump's relentless criticism has become a sideshow, adding an extra layer of drama to an already tense courtroom environment. Financial controller's testimony. Jeffrey McConney's return to the witness stand revealed insights into the Trump Organization's financial practices. McConney emphasized his reliance on external accountants, particularly Mazars USA, to prepare Trump's financial statements. However, questions arose about document disclosure, as McConney denied withholding any information from the external accountants, contradicting earlier testimony from Mazars USA accountant Donald Bender. During his testimony, the Trump Organization's controller admitted to overvaluing Ivanka Trump's apartment in a financial statement. The apartment's rental agreement included an option to purchase it for $14 million, but it was valued at $45 million in Donald Trump's statement for 2014 and 2015. The mistake was later corrected, and the value matched the actual buyout price of $14 million from 2016 onward. McConney claimed that he was not aware of the provision in the rental agreement. Insurance expert's testimony. Insurance expert David Miller faced scrutiny during cross-examination, with State Attorney Andrew Omar highlighting inconsistencies between Miller's testimony and his own expert report. The defense's attempt to portray the Trump Organization's interactions with insurers as routine business decisions faced challenges as Miller's statements appeared inconsistent with his expert findings. At one point Judge Arthur Engoron asked, "What am I missing? It seems completely inconsistent." Miller clarified that underwriters have cited external sources like media reports before, but the Zurich document marked the first time he specifically saw Forbes and USA Today cited as sources. Engoron expressed his skepticism regarding Miller's expertise in the matter after he spent 20 minutes detailing his professional experience. Neither Engoron and State Attorney Andrew Omar were not convinced of Miller's ability to testify about the decisions made by Zurich and Aon. They deemed his testimony as a waste of time. In conclusion, as the trial proceeds into its second week of the defense's presentation, the legal landscape remains complex and contentious. With the defense making strides in presenting its case, the coming weeks are poised to bring further revelations and confrontations. The nation watches as the fate of Donald J. Trump hangs in the balance, awaiting Judge Engoron's final ruling that will shape the legacy of this landmark civil fraud trial. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.